The State Capture Commission of Inquiry has filed an urgent application at the Constitutional Court calling for former President Jacob Zuma to be arrested for 2 years. Last week, the former president was a no-show at the commission, defying a Constitutional Court ruling that compelled him to appear before the Zondo Commission from the 15th to the 19th of February. We're joined now by News 24 senior legal journalist Karyn Maughan to talk a little bit more about this. Karyn, a very good evening to you. First of all, is this a surprise given the fact that there was a lot of speculation if the commission would, quote unquote, have the guts to do this? But is it also the appropriate call?
Well, absolutely. I mean, bear in mind that throughout this commission's over 2-year tenure, it's had over 250 witnesses, all of whom have come to the inquiry, some of them, 99 of which were subpoenaed. But as yet, apart from, former SAA board chairperson Dudu Myeni, no one refusing to come or answer questions. And the way in which the inquiry has framed this application before the Constitutional Court is not just centered on Jacob Zuma's self-described defiance of the Constitutional Court's directives and orders that he appear and answer questions that did not incriminate him. It also brings in his recent utterances about the judiciary, including the Constitutional Court, effectively describing them in the same terms as the apartheid government for expecting him to answer questions that did not incriminate him. Of course, he's also made other statements imputing the judges who sealed the record in the CR17 election campaign funds case involving the public protector had done so with corrupt motives. So Itumeleng Masala, the inquiry secretary, arguing today that this was really a time for the Constitutional Court to step up and, in his words, defend the judiciary.
Well, we'll see what the Constitutional Court would have to consider and how they will deliberate, just in terms of procedurally. But what the commission is also calling on is for the former president to be sanctioned for failing to submit affidavits, or his failure and refusal to do so. So let's go through what those affidavits were that were requested and why they are important.
Well, essentially what happened was, under the regulations that are available to Deputy Chief Justice Raymond Zondo, he instructed Jacob Zuma to provide affidavits specifically in relation to his involvement in the affairs of Eskom and the Passenger Rail Agency of South Africa. Now, we know that Jacob Zuma has chosen not to respond to the testimony given against him by some, close to several dozen witnesses who have, on the version of the inquiry, implicated him in wrongdoing. He claims he has a right not to do so. But in relation to this PRASA and Eskom evidence, the directives of the regulations of the Commission explicitly state that a failure to provide the Commission with this evidence that it requests under these particular regulations amount to an offence. And that is why the inquiry is pursuing that matter within the framework of this particular case.
Now, Karyn, we saw this weekend the criticism against the commission by the Jacob Zuma Foundation, suggesting that, first of all, there is something malicious about suggesting that Jacob Zuma should face time in jail as opposed to a fine and or possibly jail terms. So just in terms of the prescripts of the commission, its terms of reference, what would be the correct decision? And given the fact that the commission was also wrapped over the knuckles for taking too long and even bringing the matter to the Constitutional Court?
Well, I'm glad you asked that question, because under the provisions of the Commissions Act, the typical sentence for contempt is one of 12 months behind bars. But what the inquiry has argued in its court papers is that it is, if Jacob Zuma were to face trial for the multiple acts of contempt that they allege that he has committed, including not showing up on the 18th of January, his walkout of the inquiry, this particular incident, the failure to hand over that evidence, he would be looking at a potential sentence of 4 years, 6 months. So they're saying that the 2 years is appropriate within that framework. And they're saying we do want direct imprisonment for him because we believe that he, in his conduct, essentially poses a massive threat to rule of law and the sanctity of rule of law within South Africa. But there is a proviso, and this is where it's important. The inquiry has suggested that the Constitutional Court may opt to give Jacob Zuma a suspended sentence under the conditions that he not only furnish those affidavits that it wants in relation to PRASA and Eskom, but that he also appears before the inquiry and answers its questions. So the ball now is very much in his court. Does he oppose this application? And if he is given a suspended sentence, does he then make a decision that despite that suspension and the repercussions of him not arriving at the inquiry, he will continue to defy it? He's publicly stated that he's prepared to go to jail, but will he stay that line in the light of this particular approach from the inquiry?
And now, another interesting thing that the Commission has said is that it wants the police minister and the police commissioner to do all they can and take all the steps to ensure that they give effect to the order. The order, do they mean by the Constitutional Court? And is there an assumption that the Constitutional Court will rule in such a way that it would involve the police ministry?
Well, I mean, it's an extraordinary situation because typically we don't see scenarios where people are sentenced to jail time outside of the context of a criminal trial. But this situation is unusual in that oftentimes in the High Court, for example, if, for instance, a particular government minister has failed to act on the directives of a court of law, the court can then call that minister in and under the threat of jail time, demand some form of compliance. And that typically happens. We haven't seen, as far as I know, a scenario where someone has actually gone to jail. So, there's this issue of does Jacob Zuma then elect to, not to go to the commission with a suspended sentence hanging over his head? Or will there be a process where the court says, well, you will face jail time, you must be arrested and taken straight to prison outside of the context of a criminal trial? And I think it's in that kind of sphere that these directives to the police minister and the national commissioner are made. However, you and I are both very well aware that the police minister, Bheki, has visited the former president at his Nkandla residence in a visit that was highly publicized. And while it is not explicitly stated in the application as far as I've read it, there is a kind of undertone of, why would this particular order be necessary in the context of a lawfully issued directive from the court? Is there a sense in which, because of the extraordinary nature of this, there may be some pushback from the authorities? Or is there a sense of the kind of political dimensions of this requiring a firm legal line in the sand? We have reached out to both the minister and the National Commissioner for comment, but as yet nothing from them.
Thank you so much, Karyn. Karyn Maughan is News 24 senior legal journalist. And of course, the police minister has said that there was a discussion, didn't go into specifics, but that the ramifications were explained to the former president.